Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 61 of the Case a Day series journey covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. I'll be the Iron Law Guy today, but I won't be wearing the mask, okay? Please be aware that the case recordings are available on TikTok, YouTube, Instagram, Facebook, Twitter and on Spotify too. Simply search Law with Dunk the Law Guy or at Dunk the Law Guy. And to law teachers and students who may prefer an electronic copy instead to read from, so far I've uploaded both PDF and Word document versions of actus reus, causation and mens rea handouts to my shop on test.com, which I hope will help you should you want these. The shop is called the Law Guy _ Law Library Shop. These resources are also available on Kindle. Once launched, I'll be uploading these to my website too, which will be called thelawguy.co.uk. Today, I'd like to cover the case of Smith v Chief Superintendent of Woking Police Station 1983 and touch upon this case's importance to the actus reus of assault, and specifically the immediacy requirement, which will come towards the end of today's recording. In this case, the defendant, who was apparently a police officer, trespassed onto a young woman's property one night and went on to peer through her window. This was around 11 p.m. The young woman has been referred to in various case summaries as Miss M. This case is seen as a very important case, as the decision in this case challenged the definition of an assault and therefore when an assault can take place. He actually entered her, so Miss M's, private garden and went on to peer through her ground floor flat bedroom window. The young woman, who was in her nightclothes, her nightdress, at the time, noticed that the defendant was staring at her and she became scared and jumped out of fear, and whilst frightened she immediately went on to contact the police. She felt violated and that her safety was at risk. The defendant also happened to keep on staring at her as opposed to running away, which led to her becoming even more frightened. At trial, the defendant was charged with an offence requiring there to be an assault under the Vagrancy Act 1824. Specifically, the offence the defendant was charged with was that of Section 4 of the Vagrancy Act 1824, i.e. being on private property, which is a tort, i.e. trespass, I believe, for an unlawful purpose, which is a crime, hence the need for there to be the criminal offence of an assault in this case. If the defendant was not on the property for an unlawful purpose, there would simply be a tort, i.e. a civil wrong, committed against the young woman rather than behaviour warranting a criminal conviction. The defendant was found guilty at trial and went on to appeal, arguing that the prosecution team failed to prove at trial that the victim apprehended immediate unlawful personal violence. Specifically, the defendant acknowledged that the victim was scared, but argued that she couldn't be scared of any personal violence due to her being inside the house at the time of the incident and the defendant being outside a locked window. A landmark case decision was produced here, as the court upheld the defendant's trial conviction and held that the defendant's actions here amounted to an assault, despite there being no physical touch or verbal threat issued by the defendant. This decision widened the grounds of when an assault could take place and specifically acknowledged how the defendant's actions had an impact psychologically on Miss M, which led to the assault here. You'll remember that the actus reus of assault is defined as an act, number 1, that causes the victim to apprehend, number 2, immediate, number 3, unlawful, number 4, violence. And the mens rea is either intention, I always stress direct intent, or recklessness, subjective recklessness, to cause the victim to apprehend immediate unlawful violence. So, wrapping up now the important parts of the judgment in this case and how it relates to the development of our understanding of how the actus reus and mens rea of an assault can be formed. are that it recognises an assault can exist where there is no expressed threat from the defendant, rather a victim's fear or expectation of an intrusion from the defendant is enough, and therefore this court judgment acknowledges that an assault can occur where there is no physical contact between a defendant and victim. This case also acknowledges how police officers need to respect people's privacy. However, one of the many truly important aspects about this case decision is how it acknowledges the emotional consequence the defendant's actions could have upon the victim here, and provides protection in law for victims by having a defendant be found guilty of an assault. Also, very importantly, this case decision helped develop our understanding of immediacy for the purposes of the actus reus of an assault. Despite the defendant not being able to enter the flat as the doors were locked, as well as the windows, the court still ruled that immediacy was proven, as in the victim's mind, she was unaware of what the defendant may do next, and this could foreseeably be something of a violent nature. And so, where a victim expects possible force may be about to happen, i.e. imminent violence or violence in the near future, then the immediacy requirement of the actus reus of assault is proven. So just like what was stated in the Day 54 recording regarding the case summary of RV Island 1997, immediacy or immediate for the actus reus of assault means where the victim expects force or violence is about to happen in the near future. Finally, it was deemed clear that the defendant entered Miss M's property with the aim of intending for her to become fearful. Hence, the mens rea along with the actus reus of assault was proven, and the defendant's conviction was upheld on appeal. And that's it for today. Thank you from Law with Dunk, the Law Guy.